Welcome back. We hope you enjoyed the coffee break. We briefly remind you that the channels for the translation are 1 for Spanish, 4 for English, and 8 for French. Now we will begin the 4th plenary roundtable. The 4th plenary roundtable, organized by the American Society of International Law, will focus on corruption, international law, and national systems. We kindly invite the following panelists. Ms. Lucinda A. Lowe, partner and international practice leader at Steptoe & Johnson, LLP, Washington, D.C. Mr. Diego Garcia Sayán, former president of the Inter-American Court of Human Rights, Foreign Minister of Peru, and Special Rapporteur on the Independence of Judges and the Legal Profession. Mr. Pedro Martínez Fraga, partner and co-leader at International Arbitration Team, Brian Cave, Lidom Pesner, Miami and New York City. And Professor Kevin Davis, Beller Family Professor of Business Law at New York University School of Law, New York City. Without further delay, we give the floor to the moderator, Ms. Lucinda A. Lowe. Thank you very much.
Muchas gracias, es un placer estar aquí con vosotros. Y antes de más nada, quería agradecer a la Sociedad Peruana de Derecho Internacional, también particularmente al embajador Mautua y todo el comité organizador, sobre todo el coordinador principal, Gonzalo Tello, que nos ayudó mucho con este evento. Ahora cambio para inglés, siguiendo la práctica de esta conferencia. So, our panel topic today is an area that has received a lot of attention over the last 25 years. And it has a close relationship to a topic we discussed this morning, the rule of law. In some ways, it is the dark side of the coin of the rule of law, and we'll come back to that. There is a lot of soft law that has been developed in this area, but also, in a very short time, a series of binding international treaties on the topic. And as many in the audience probably know, the treaty movement started here in the Americas in 1995 with the Inter-American Convention Against Corruption, which was the first instrument of its kind in the world. Other regional instruments followed from the Council of Europe, from the European Union, from the African Union, none in Asia, some sub-regional instruments, and some targeted instruments. For example, the OECD in 1997 adopted a convention which is focused exclusively on the topic of bribery of foreign public officials in international business. And finally, in the early 2000s, we had a global convention from the United Nations, the United Nations Convention Against Corruption, or UNCAC, as we call it, that has received almost universal adherence in a relatively short period of time. Now, what did these instruments do? I call this the architecture. These instruments created some directly enforceable obligations, as well as a framework for others. What do I mean? Directly enforceable. There are provisions on international cooperation, mutual legal assistance, extradition, trying to advance investigations and enforcement activities that are cross-border. But most of the provisions of these conventions require implementation at the national level. And this is true whether you're talking about the preventive aspects of the convention, which include both public and private sector measures. In the public sector, things like codes of conduct for public officials, asset disclosure, declaration requirements, and the like, or all of the conventions have criminalization provisions for various types of corrupt practices. And then in the United Nations Convention, you also have important provisions found in no other treaty that deal with the topic of asset recovery, which is a very important topic for many countries who see monies disappearing from their national treasuries and going into the treasuries of other countries as a result of corruption. ¿Qué preciso hacer? Okay. So this sets up a relationship, a symbiotic relationship through the non-self-executing character of many of these conventions between international law and national law, which we'll talk about more in the course of this panel. Now, many of these international instruments have monitoring mechanisms to be able to track what is being done to implement the conventions at the national level. You can't join the OECD bribery convention without also joining the working group on bribery, and they have a peer review mechanism which is very intense and detailed. But also the Inter-American Convention has a mechanism and others, and so they prepare and publish reports following what countries are doing to implement. Now, despite all of these instruments, there are many questions of effectiveness, 25 years on. There's a perception that corruption, particularly in the public sector, but also in areas like sports and others, continues unabated. Enforcement is uneven. There is some fatigue that has set in with respect to monitoring. Countries get tired of always having visitors coming to examine what they're doing. And there are other important issues, of course, that divert attention. And so that has led to questions being raised about what can be done at this stage to increase effectiveness. I've been part of a project that the International Law Association did last year and ultimately published earlier this year a white paper on corruption, taking stock of where we are and what needs to be done. And for those who are interested, it's easily available. Just Google ILA white paper on corruption. So I was part of the steering committee that prepared this document, and we had the opportunity to interview leading thinkers around the world and people involved in the fight against corruption in various ways, which was extremely interesting. So I'd like, as a stage-setting exercise for the interventions that will follow, to tell you a little bit about what we found. The starting position of the white paper was that the legal and institutional framework is largely in place. It's not the framework that is lacking as a general matter. Now, there are some gaps that we'll talk about, but it's implementation in the very broadest sense of the term that is the biggest issue. And there are various reasons for these implementation challenges. It can be lack of political will. It can be lack of resources, either human or financial. Remember that this is a complex topic. And by the way, none of these conventions define corruption. We can come back to that, but that's not a trivial detail. But lack of political will, lack of resources, insufficient coordination or cooperation, both among countries and within a country. Challenges with the process of mutual legal assistance for these complex financial crimes, and some gaps in the legal framework at the national level. We were talking today at lunch about the question of immunities under international law for government officials and how those may be used and sometimes abused in this area. But there are also issues with respect to the liability of legal persons in the criminal arena and civil liability standards. And as we'll hear in our panel, the question of civil liability is really an area that has not been well developed. And corruption, when you talk about that undefined term, is more than bribery, although bribery has been the primary focus for the last 25 years. But think about the other issues that many people associate with the term corruption. Kleptocracy, state capture, trading in influence, lobbying, conflicts of interest, and what the Indonesians call KKN, corruption, cronyism, nepotism. So there are lots of associated issues in this bundle. These were all challenges that the ILA paper highlighted. They also highlighted the lack of a holistic approach to the problem. Binary approaches have been predominant. People talk about petty corruption versus grand corruption. They talk about supply side or active versus demand side, passive. I've never liked active and passive, but that's a different story. Foreign versus domestic, rich versus poor. So these binary approaches sometimes obscure thinking about the problem in a more holistic way. It's also been difficult to resolve cases on a global basis. Countries are coordinating more today than ever before in investigations and enforcement of cases, but there's still many issues with respect to what you do with the victims of corruption. Who are the victims? How do you make reparations to them? What about the issue of asset recovery? How do you get your arms around a problem that is hidden almost by definition? And so your data, even the basic information, can be very hard to get. So these are some of the challenges. It's not an easy problem. As a lawyer, it can make you very humble, in fact, because it's very tied in with social, economic, political issues. So what is the possible way forward? And I'm still talking about the white paper at this point. The white paper focuses on 9 things. The first is increased international cooperation, both among national authorities in enforcement, on the supply side and on the demand side, with the private sector in prevention, increased harmonization. These are, the criminalization relies on the domestic legal systems of countries, and so trying to harmonize investigation and enforcement tools. Harmonization across treaties, although there's a degree of consistency, they're not entirely consistent. So those are some of the recommendations in that first bucket of international cooperation. The second is increased transparency. Of what? Increased transparency of the borrowing of sovereign wealth funds is one issue we heard about. Disclosures of payments to governments by private sector companies. Asset declarations of government officials, improving the quality and timeliness of those and the transparency of those. Funding of political parties. This is a big problem in the United States, where I come from. Corruption of the political process and transparency in public procurement. So there's several important things in the transparency bucket. There's also a need to focus on prevention. A lot of steps have been taken in this area, but prevention is an important strategy. There's a great deal of movement around the fourth recommendation, which is stop sheltering dirty money. There are calls in the white paper for eliminating tax havens, regulating people who are referred to as enablers. That can be people who form companies, it can be lawyers, it can be other disciplines, but who enable the flow of dirty money. There's a movement toward beneficial ownership transparency in a number of countries. We've passed legislation in the US, but Europe was before us, the UK was before us. So there's a move for those, and undisclosed wealth orders that can require public officials and others to disclose the source of their money. The fifth recommendation involves involving all stakeholders, looking at collective action, industry by industry, increasing awareness of the public and civil society. Building knowledge is the sixth, helping people understand the impact of corruption on victims. harnessing artificial intelligence and digitization, making more data open and accessible to people, including in civil society, increasing media coverage, building capacity, educating civil servants, promoting integrity in government, better measures to combat conflicts of interest, and the final one is rethinking the role of international organizations. And that's a long, complex topic that I will not try to get into here. These recommendations that I've just gone through are extensive, but they're not necessarily comprehensive. They don't focus on specific sectors. They don't focus on the role of lawyers and judges, although several of the recommendations will implicate them. And as I said, this is a really deep problem that law alone cannot solve, but law is part of the solution. So with an attempt in this panel, what we're going to try to do is focus on a few topics that reflect some of the most significant issues, lessons learned, and gaps that come out when you look at the current state of the fight against corruption. And first, we're going to focus on judges and the legal profession. And for that, I'm going